point out that that is a possibility considered in the Commission's order that was part of the notice of hearing, Federal Register notice. If the...
Where? Give us a reference to that.
The Federal Register notice itself.
To the part where the Commission made a specific, said anything whatsoever that should lead us to a conclusion that we should make a ruling of this nature.
My point, Judge, referring to the Federal Register notice, was that there is a possibility that Sunseed access can be denied. That's the whole point of an access.
And there's something in the Federal Register notice to suggest that determination should be made prior to reaching that point? What is the practical reason for doing it now rather than after the point at which any determinations are made on access?
As a practical matter, this is a contention purely of omission. And if the information has been provided, which the staff has received and accepted the information and says that it has now been provided on the docket, the board has access to that information to make its determination. Access by the petitioners is not necessary for the board to review that information and determine whether or not the contention, that portion of the contention, is now moved.
All right. If the parties would like to brief this issue, you're free to do that. And we'll set any necessary deadlines for you to do that. But I personally would expect to get some good legal authority for the argument that we should, especially at this point, make any ruling based on information of which all parties are not aware. I mean, the general case law out there in the rest of the world, we're talking about very cutting-edge issues. And you're blithely arguing to us that we should make a ruling based on information that the petitioners don't have access to. And so before we do that, I will expect to get briefs from all parties on any legal authority that we have any authority to do that, especially at this point. So one would be the authority for us to do that and the extent to which that goes. And two would be why we should do that now rather than wait until later. And I haven't heard one practical reason that would persuade me at this point that there's any benefit in doing this now rather than a few months down the line, how that would make any difference to anyone such that we should do it at this point. The applicant says that we should do it at this point because that might result in petitioner getting party status. I'm not sure I follow the logic of that. That could be included in the brief. But certainly, brief this further before you got any ruling from us of that nature, at least from me.
Well, Judge, perhaps I misunderstand the board's position, but my point, the simple point I'm trying to make is that the board has the authority to make the decision on this contention even if the petitioners are not allowed access to that information. And if you look at the inverse of the situation, if the board refuses to rule on this contention until the petitioners are granted access, that is an assumption that they would be granted access under the
Mr. Biggins, you're not listening very well or you're not understanding very well. My question to you is, why should we even make a determination on this until the access determination has been made? I might also point out that we're talking not about safeguards information or classified information. We're talking about unclassified, non-safeguards information, and whether they should have access to that so that they can draft a contention that addresses the information to which they now do not have access. And I don't think you realize how unusual the arguments you're making are. I mean, these are issues on which cutting-edge rulings and determinations are being made now. And we're talking about national security being involved, which generally would involve classified information. And you're talking about non-classified, not even safeguards information. So let's just, unless you really have some, just hold on.
Yes, Judge.
Unless you really have something that you really need to say now about this, I think you should refrain and file a brief on this further. So what do you need to say now?
I do not disagree with the board that you could wait until the sunset determination could be made.